Hi, welcome to the Madrid Doctrine. My name is Andrew Madrid, and today we're going to discuss child support. Now, before I continue any further, I would like to clarify that I am not an attorney and this is not legal advice. With that being said, let's jump right on in. Are you on child support? Or do you know someone who's on child support? Well, for most, the answer is yes. Now, sadly, there are so many people who are on child support right now. And child support is a very difficult and touchy subject. But here, we're going to simplify things and make it easier for you to understand. So let's jump right on in. One of the very first issues at hand is that so many people are led to believe that they do not have any rights. And what I'm here to tell you is that we all have rights. The only issue is that you have to stand up and you have to fight for your rights. But how can you stand up and fight for your rights if you don't know what your rights are? So for anyone that is on child support, we're going to jump right in to a case called Troxell versus Granville in the year 2000. And it was a United States Supreme Court case that was heard, which is in regards to parental rights. Now, I know that during child support litigation, so many people are led to believe that they don't have any rights. But Troxell versus Granville is a very good case to help you understand that even if you are going through a divorce or separation, or maybe you were never married before at all, that as a parent, you do have rights. So, let's jump right on in. In Troxell versus Granville, it was a case about a mother named Tommy Granville, and she had two children, Isabel and Natalie. Now, Tommy Granville was not married at all. She had a romantic relationship with an individual named Brad Troxell, and during that relationship they produced two children. And this case stems from the sad and misfortunate event of Brad's death. Unfortunately, he did commit suicide. So let me begin by giving you a little information about Troxell versus Granville. Tommy Granville and Brad Troxell shared a relationship that ended in June of 1991. The two never married, but they had two daughters, Isabel and Natalie. Jennifer and Gary Troxell are Brad's parents, and thus the paternal grandparents of Isabel and Natalie. After Tommy and Brad separated in 1991, Brad lived with his parents and regularly brought his daughters to his parents' home for weekend visitation. Brad committed suicide in May of 1993. Although the Troxells at first continued to see Isabel and Natalie on a regular basis after their son's death, eventually Tommy Granville discontinued that visitation time. Now, what occurred after that is Jennifer and Gary Troxell, which were the grandparents, they wanted to continue seeing their granddaughters. But the problem is that their mother made a decision and said that she didn't want the children to spend so much time with the grandparents. So what it comes down to is Tommy Granville, the mother, of Isabel and Natalie. She was not outright refusing for Jennifer and Gary to see their grandkids, but she was trying to limit the time available with them. Now, we don't know what Tommy's reasonings were at the time. From the court documents, there's no way of telling. But the point is that it really doesn't matter why Tommy made the decisions that she did. The fact of the matter is that Tommy is the mother of the two girls. So that's really the only issue that matters, is that one parent committed suicide, which is a very it's an unfortunate event. But although the children lost one parent, the children still had another parent. And so the problem really arises where two people, which are the grandparents, are trying to override a parent's decisions. Now, for most, I think most of you would realize, you would feel that that's not appropriate. But in this case, the grandparents didn't like Tommy's decisions, and they're willing to take her to court. Now, it's very interesting because the case went up through the courts in the state of Washington. It went all the way to the Washington Supreme Court. Now, from there, it went to the U.S. federal courts and worked its way all the way up to the United States Supreme Court. So the United States Supreme Court actually made the decision in this case. And here I'm going to read an excerpt from the case about the Supreme Court's opinion in the matter. The 14th Amendment provides that no state shall deprive any person of life, liberty, or property without due process of law. We have long recognized that the amendment's due process clause, like its Fifth Amendment counterpart, guarantees more than fair process, and that is Washington versus Guxberg. The clause also includes a substantive component that provides heightened protection against government interference with certain fundamental rights and liberty interests. And that's from Reno versus Flores. The liberty interest at issue in this case, the interest of parents in the care, custody, and control of their children, is perhaps the oldest of the fundamental liberty interests recognized by this court. More than 75 years ago, in Meyer versus Nebraska, we held that the liberty protected by the Due Process Clause includes the right of parents to establish a home and bring up children and to control the education of their own. 2 years later, in Pierce versus Society of Sisters, we again held that the liberty of parents and guardians includes the right to direct the upbringing and education of children under their control. We explained in Pierce that the child is not the mere creature of the state, that those who nurture him and direct his destiny have the right, coupled with the high duty to recognize and prepare him for additional obligations. We return to the subject in Prince versus Massachusetts, and again confirmed that there is a constitutional dimension to the right of parents to direct the upbringing of their children. It is cardinal with us that the custody, care, and nurture of the child resides first in the parents, whose primary function and freedom include preparation for obligations the state can neither supply nor hinder. In subsequent cases, also, we have recognized the fundamental right of parents to make decisions concerning the care, custody, and control of their children. That's Stanley versus Illinois. It is plain that the interest of a parent in the companionship, care, custody, and management of his or her children come to this court with a momentum for respect, lacking when appeal is made to liberties which derive merely from shifting economic arrangements. That's Wisconsin versus Yoder. The history and culture of Western civilization reflect a strong tradition of parental concern for the nurture and upbringing of their children. This primary role of the parents in the upbringing of their children is now established beyond debate as an enduring American tradition. We have recognized on numerous occasions that the relationship between parent and child is constitutionally protected. Parham versus Jr. Our jurisprudence historically has reflected Western civilization concepts of the family as a unit with broad parental authority over minor children. Our cases have consistently followed the course. Santosky versus Kramer. The fundamental liberty interest of natural parents in the care, custody, and management of their children. Glucksberg Supra. In a long line of cases, we have held that in addition to the specific freedoms protected by the Bill of Rights, the liberty specially protected by the Due Process Clause includes the right to direct the education and upbringing of one's children, citing Meyer and Pierce. In light of this extensive precedent, it cannot now be doubted that the Due Process Clause of the 14th Amendment protects the fundamental right of parents to make decisions concerning the care, custody, and control of their children. First, the Troxells did not allege, and no court has found, that Granville was an unfit parent. That aspect of the case is important, for there's a presumption that fit parents act in the best interest of their children. As this court explained in Parham, our constitutional system long ago rejected any notion that a child is the mere creature of the state, and on the contrary, asserted that parents generally have the right, coupled with the high duty, to recognize and prepare their children for additional obligations. The law's concept of the family rests on a presumption that parents possess what a child lacks in maturity, experience, and capacity for judgment required for making life's difficult decisions. More important, historically, it has recognized that natural bonds of affection lead parents to act in the best interests of their children. Accordingly, so long as a parent adequately cares for his or her children, example is fit, there will normally be no reason for the state to inject itself into the private realm of the family, to further question the ability of that parent to make the best decisions concerning the care of that parent's children. Flores. Well, there you have it. The Supreme Court of the United States has made it clear that parents have rights,